Does merely smelling the odor of cannabis give police in Canada the right to search your vehicle? Today on Don't Talk TV, I'm going to answer this question. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. In some ways, being inside your motor vehicle can sometimes seem like being in a charter-free zone. Police have many more powers to detain you and search you when you're in a motor vehicle than they do at other times and places. Part of this is because driving a motor vehicle, as is frequently stated, is, quote, a privilege, not a right, unquote, and it's a licensed activity. Therefore, the police can detain you at any time to make sure that you have that license with you for conducting that activity. With the advent of the legalization of cannabis, this raises some interesting questions about whether merely smelling cannabis is enough for police to search your motor vehicle. I think it's very important for people to understand what police can do and what they cannot do. Now, this certainly isn't so that individuals can be disrespectful to police or that they should be obstructionist or difficult with police, but I think it will highlight why it's absolutely important to never ever consent to a search, because frequently police will use words to the effect of, well, I'm going to search the vehicle anyway, so you should just consent. I see this all the time in cases, and all too often I see individuals being intimidated by that and then consenting to a search of their vehicle, thereby giving the police an ability to search a vehicle that they would not have had otherwise. Whereas by refusing to consent, that leaves me or another lawyer of your choice much more ammunition for fighting the unlawful search. So firstly, in general, let me just review the circumstances under which police can conduct a warrantless search of your vehicle. So firstly, in the context of challenging this in court, in order for you to raise the issue of an unlawful search, you have to show that you had a reasonable expectation of privacy in the place that was searched. Put another way, police can search anything that people don't have a reasonable expectation of privacy in. Showing a reasonable expectation of privacy in a motor vehicle will depend on a number of factors, including who owns the vehicle, who has the usual use of that vehicle, who has the ability to say who can or cannot use that vehicle. It'll depend on whether it's the driver who's trying to claim that privacy right. Now, motor vehicles do have a lessened expectation of privacy than things such as your residence, but there is still a legitimate expectation of privacy. Certainly, the owner of the vehicle will have much more privacy interest, as will a driver versus a passenger or versus an individual who is merely borrowing the vehicle. Assuming that you can show that you have that reasonable expectation of privacy, or you do have that reasonable expectation of privacy in the vehicle, any search without a warrant is then presumed to be unlawful, and it goes on to the Crown the duty to prove that it was lawful. So the police are going to have that in mind, that they need to justify why they're doing a warrantless search. And in order to justify the warrantless search, they have to show that the search was authorized by law, that that authorizing law is reasonable, and third, that the search was done in a reasonable manner. Specifically dealing with a search of a vehicle based upon the odor of cannabis, police are going to be relying on Section 87 of the Cannabis Act. So Section 87 sub 1 gives the power on a justice on an ex parte application who's satisfied by information on oath that there's reasonable grounds to believe that any of the following is in place may issue a warrant. So the circumstances under which that warrant can be issued are A, they believe in the place to be searched there is cannabis in respect of which this act has been contravened. B, anything in which cannabis in which this act has been contravened is contained or concealed, offense-related property, or D, anything that will afford evidence in respect of an offense. Basically, in layman's terms, if there is unlawful cannabis or a container that may have unlawful cannabis in it, those are the grounds on which a search may be conducted. And then Section 7 allows a peace officer to exercise the powers of a search without a warrant if the conditions for obtaining a warrant exist, but by reason of exigent circumstances it would be impracticable to obtain one. Police are always going to use that at the side of the road. They're going to say it's exigent circumstances because you could just drive away if they don't search your vehicle then and there. So it's going to come down to whether they can show reasonable probable grounds to believe that there is unlawful cannabis in your vehicle. Now, in the past, all cannabis was illegal, so arguably the smell of cannabis automatically would mean that there's a suspicion that there's unlawful cannabis, since you simply couldn't own it prior to the Cannabis Act. However, now only certain types or amounts of cannabis are unlawful. So in order for police to have reasonable grounds to search your vehicle, they'd have to reasonably believe that you have more than 30 grams of cannabis in your vehicle. That you have illicit cannabis in your vehicle. If, as a young person, if you have more than 5 grams of cannabis in your vehicle, none of these things can be determined from the mere odor of cannabis. I would suggest that they'd have no way of knowing whether the smell of cannabis, if they even smell the odor of cannabis, they have no way of knowing what they're smelling is something that you just purchased from the OCS. They have no idea if it's something that from one of your legally grown plants at home. They have no idea whether they're just smelling cannabis because a couple days ago you smoked a joint while you were wearing the sweatshirt that you're wearing when the police pull you over. Now, even before the Cannabis Act, it was already difficult for police to search a vehicle based merely on the smell of cannabis. The Ontario Court of Appeal in the 1999 decision, Her Majesty the Queen in Polishek, said that merely smelling the odor of cannabis does not automatically give the police the right to search a motor vehicle. Now again, keep in mind, that was 1999 when all cannabis was illegal. The Court of Appeal in Polishek said that allowing a search based only on an odor of cannabis is highly problematic because smell is highly subjective, it's largely incapable of objective verification, and can hide discriminatory motivation. Now, there were cases that go the other way. There were cases where police would say that, well, I have special training or I have a bunch of experience from having been in the drug unit, therefore my sense of smell is better than other individuals and I'm able to determine that there's cannabis. But again, these are all in the context of any amount of cannabis or any kind of cannabis being illegal. In the context where there are numerous legal avenues to have cannabis with you or to have the smell of cannabis about your person, in my view, the Crown would not be able to succeed in convincing court that simply off an odor, the police had rights to search a vehicle. So if you're ever pulled over and the police stick their head in your window and say, oh, I smell weed, I'm going to search your vehicle, or I smell weed, can I search your vehicle? Never consent to searching a vehicle. Call a lawyer right away. And again, I just want to reiterate, don't be disrespectful to police. Don't start fighting with them. Don't try driving away. Don't do anything like that, because those could all be crimes in and of themselves. But declining to consent to a search is absolutely not an offense. If a police officer asks you, do you mind if I search your vehicle? You should politely respond, yes, sir, I do mind. I do not consent to you searching my vehicle. And then if the officer says, well, why? What do you have to hide? Or why don't you want me to search the vehicle? You can simply state, nothing in my vehicle concerns you, sir, or with all due respect, sir, the contents of my vehicle are private. And then if the officer persists, I would suggest that you pull out your cell phone and call a lawyer. Might not be a bad idea to record your interaction with the police as well. If the police threaten to bring a canine unit to sniff for drugs, you should still not consent to anything. The police are going to do what they're going to do. If they bring in the canine, so be it. These are all things that a lawyer can deal with at court on your behalf. But in order to protect yourself, you need to remain silent, record the transaction if you are able to, and contact a lawyer. This is not legal advice specific to your situation. As I've said, contact another lawyer or contact myself at my 1-855 number below so that you can receive specific legal advice tailored to your situation. So on this episode of Don't Talk TV, we've discussed whether police can search your vehicle without a warrant merely based on the odor of cannabis in your vehicle. And simply stated, they cannot, and you should not consent to any such searches.